The knock wasn't casual. It was the kind you hear through walls. I checked the time on my phone, 7:18 a.m. My coffee was still in the machine, dripping in slow, measured clicks. I looked through the peephole and saw a uniform, a clipboard, and a second man standing a half step behind with his hands folded like he'd done this before. When I opened the door, the deputy didn't greet me. He held out a packet, stapled thick, and asked my name. I told him. He read the name off his paperwork anyway, like the sound of it in my mouth didn't matter. "This is a writ of possession," he said. "You've got until noon." I took the packet with both hands the way you take something that's heavier than paper. The top page had the county seal and a case number. The second page was a schedule of enforcement. My address was printed in black, correct down to the apartment letter. The deputy didn't step inside. He didn't need to. "Your belongings need to be removed," he said. "If you're still here at noon, we will remove you." "Based on what?" I asked. He tapped the page with a pen. "Court order. You can read it. I haven't been to court." He looked at the second man, then back at me. "Then you need to go." The second man finally spoke. His voice was practiced, neutral, the tone of someone who could say anything as long as it was in procedure. "I'm the trustee's agent," he said. "If you cooperate, it goes smoother." They turned and walked down the hall before I had time to ask which trustee, what trust, whose authority. The deputy paused at the stairwell and said one more thing without turning fully back. "Don't make us come back with a locksmith and movers." The hallway went quiet after their footsteps faded. The coffee machine clicked off in the kitchen. The apartment felt smaller, like the paper in my hand had tightened the air. I sat at the table and opened the packet, page by page, flattening each sheet as if smoothing it would change what was written. Plaintiff, Meridian Harbor Trust. By and through appointed successor trustee. Defendant, occupants. There was no name after occupants. No John Doe, no Jane Doe. Just a category. The order referenced an unlawful detainer judgment entered 3 weeks earlier. I read the date twice, then checked my calendar. 3 weeks earlier, I'd been on a job site 2 counties over, sending photos to a client at 9:06 p.m. from the same phone that now showed 7:26 a.m. I read the service section, substitute service, posted and mailed. It listed an address that wasn't mine. It was close, but one digit was wrong. 1. The apartment number was mine, but the street number was off by 1, like someone had copied it from memory and didn't care enough to verify. At the back of the packet was a notice of hearing. The hearing date had already passed. A default judgment had been entered because no one appeared for the defense. Occupants hadn't appeared. Occupants didn't have a mailbox to check. Occupants didn't hire counsel. Occupants didn't exist as a person who could sit in a courtroom and say, calmly, that the address was wrong and the service never happened. I flicked the packet again until I saw the signature line. A judge's signature, printed name below it, stamped seal beside it. It looked final. I stood up and walked to the small filing cabinet I kept next to the pantry. Inside was a folder labeled with my father's name. I hadn't changed the label since the day I made it because the file wasn't about my comfort. It was about record. My father died 8 months earlier. Heart failure. He wasn't young, but he wasn't supposed to be gone that quickly. He left things in order. At least he thought he did. I'd been the one who went to the hospital and signed the release forms and carried his effects home in a paper bag. I'd been the one who found the original deed for this apartments building among his papers. A deed he'd never boasted about but had quietly paid into for years. He owned the building outright. 4 units, an old structure with a solid foundation and a tax history that told a straight story. When he died, I moved into the upstairs unit to keep it stable while probate moved. My job allowed it. I didn't need permission from anyone who actually cared about the property. Because I was maintaining it, utilities, repairs, tenant issues, insurance renewals. I'd been paying property taxes out of an estate account that still had money because I cut every expense that wasn't necessary. 2 months after the funeral, my stepmother, Diane, called me and said she needed space from the reminders and that I should handle the property details because you're good at that kind of thing. She said it the way people say they're doing you a favor by letting you do work. I didn't trust her. I didn't trust my half-brother Eric either. Eric had learned early that appearing calm could substitute for being honest. He'd always been good at walking into a room and making other people adjust around him. But distrust isn't evidence. It's just a tension with a memory. I opened my father's folder and pulled out the certified copy of his will. Not the version Diane had handed me at the wake, but the one I'd requested myself from his attorney and then verified with the clerk's office when probate started. I'd done it quietly because I'd learned that asking for permission in family matters only teaches people where your boundaries are. The will named me as executor. It also named me as the specific devisor of the building, subject to a life estate for Diane in the downstairs unit only. My father's handwriting wasn't on the will, but his instructions were. He told me in one of the last clear conversations we had that he didn't want Diane managing anything with tenants, not because he hated her, because she didn't understand that rent was a contract and not a personal insult, a life estate in one unit, not ownership of the building, not authority to sell, not authority to form a trust and call it Meridian Harbor. I kept reading my own documents, as if the pages would begin to argue with the court order and win by themselves. At 7:41 a.m., I called the number on the writ packet for the trustee's agent. It went to voicemail immediately. "This is the occupant at the address you listed," I said. "I received a writ this morning. I haven't been served. I'm the executor of the estate that owns the building. Call me back within 30 minutes. You have the wrong party and the wrong address in your service declaration." I didn't add anger. I didn't need to. Anger doesn't leave a timestamp. Then I called the deputy's office. I asked politely whether the execution could be delayed pending verification of service. The woman on the phone told me, also politely, that they were executing what the court had signed. She said the court was the place to address errors. I had 4 hours and 19 minutes until noon. I showered quickly, dressed in plain clothes, and packed what mattered into a small bag: my father's will, the letters testamentary that had been issued early in the probate process, the most recent property tax receipts, the building insurance declarations page, and my phone charger. I also printed out my call log showing the voicemail to the trustee agent. I knew it might not be admitted anywhere. But I also knew that timestamps have a way of making people more careful. Before I left, I walked through the unit and took slow video on my phone. The furniture, the cabinets, the appliances, the condition of the floors. I narrated only facts quietly to tie the recording to that morning and that place. "Kitchen, 7:58 a.m., no visible damage," I said. "Bedroom, dresser, contents intact." I emailed the video to myself and to a second account I kept for estate matters. If my phone was lost, the record wouldn't be. At 8:12 a.m., I drove to the courthouse. The courthouse parking lot was half full, early enough that people still moved with purpose instead of resignation. I walked in with the bag on my shoulder and went through security. The metal detector beeped because of my keys. I put them in the tray again and walked through. The deputy inside didn't look at me. He didn't need to. Inside a courthouse, most people are already punished. The clerk's office for civil filings had a row of glass windows and a line that was just long enough to feel like a system. I stood behind a man holding a manila envelope and a woman clutching a small stack of papers with both hands like she was afraid it might run. When I reached the window, the clerk didn't look up at first. She typed, clicked, then finally lifted her eyes as if allowing me into her time. "How can I help you?" she asked. "I was served with a writ of possession this morning," I said. "I need to file an emergency motion to stay execution. The service address is wrong and the defendant is listed as occupants." She held out her hand without a word. I slid the writ packet under the slot. She read the first page, then typed the case number into her screen. Her face didn't change. Her mouth moved slightly at one corner, the expression some people use when they've already decided what the answer will be. She slid the packet back. "You're not listed," she said. "What do you mean?" I asked. "Case is Meridian Harbor Trust versus Occupants. You're not a named party. You can't file anything unless you're counsel of record or a party." "I'm the person being removed," I said. "I'm the executor of the estate that owns the building. This is my address." She gave a small, controlled smirk. It wasn't dramatic. It was worse. It was casual. It said she'd watched people fail here and had learned to enjoy the predictability. "I'm telling you what the system shows," she said. "You're not listed." I kept my voice level. "Is there a way to file a motion as an interested party or to intervene?" She clicked her mouse. "You need a lawyer." "I don't have time," I said. "I have an enforcement scheduled at noon." She shrugged, minimal, like the weight of noon belonged to someone else. "That's what the writ says." Behind me, the line shifted. Someone exhaled sharply, a small sound of impatience. The ordinary pressure that pushes people out of systems faster than any rule. I pulled out my letters testamentary and placed them under the glass. "These show I'm executor. Probate case is active. The building is an estate asset. This trust is not authorized." She looked at the letters, then at me, then back at her screen. She didn't read them closely. I could tell. She'd already decided which category I belonged to. "Not listed." "Different division," she said. "Probate is upstairs." "I'm being evicted on a civil writ," I said. "Signed by a civil judge. I need a stay." She leaned closer to the glass and lowered her voice slightly, as if she was sharing a secret instead of stating a barrier. "If you're not listed, you're not listed, Yossat," she said. "That's how it works." I took my papers back. I didn't argue with her. Arguing with a clerk rarely changes anything. What changes things is making the clerk answer to someone else. I stepped away from the window, moved to the side, and looked at the writ packet again. The plaintiff name, Meridian Harbour Trust, looked designed. Not like a family trust with a surname, like a brand. The attorney listed on the complaint was a firm I'd never heard of. There was also a phone number for the plaintiff's counsel. I called it. A receptionist answered. I asked for the attorney listed on the documents. She put me on hold. A minute passed. Then two. The hold music was clean, corporate, designed to make time feel ordinary. At 8:47 a.m., an attorney came on the line. His voice was efficient, not rude. "This is Mr. Landry," he said. "How can I help you?" "My name is Daniel," I said. "I received a writ of possession this morning for a property owned by the estate of my late father. Your case lists the defendant as occupants and claims substitute service at the wrong street number. I'm asking you to stipulate to a stay pending proper service." There was a pause. I could hear him reading, typing, doing what people do when they try to find the quickest path to end a call. "We served as required," he said. "If you believe service was improper, you can raise that with the court." "I tried," I said. "The clerk told me I'm not listed." "That's because you're not the defendant named," he said, like it was my fault I wasn't named. "I'm the person the deputy will remove at noon," I said. "You're using a category instead of a name to avoid opposition." His tone tightened slightly. "That's an allegation." "It's a description," I said. "Who created Meridian Harbour Trust?" "I represent the trust," he said. "I don't discuss client formation over the phone." "Then discuss the error in your service declaration," I said. "The street number is wrong." He didn't respond immediately. That told me he was looking at the document. People often ignore what they can't be forced to answer, but once they see an obvious error, they have to decide whether to lie or pivot. "I see the address," he said finally. "If you're at a different number, you can submit proof to the court." "There's no time for that if you enforce at noon," I said. "I'm asking you to agree to a temporary stay." "We won't stipulate," he said. "Our client has been delayed enough." "By what?" I asked. He exhaled once, controlled. "If you have a probate dispute, handle it in probate." "It's not probate today," I said. "It's the deputy at my door." His voice went colder. "I've given you the answer. Good luck." The line went dead. At 8:59 a.m., I went upstairs to probate anyway, because I needed something the civil clerk couldn't deny, a case where my name was listed, my authority was documented, and the building was already identified. Probate had its own counter. Fewer people. More paper. The clerk there was older, with reading glasses and a pen tucked behind one ear. She looked at me when I approached. I need to see the docket for the estate of Thomas Hale, I said. She typed, then nodded. You're the executor, she said, not as a question. Yes, I said. I need certified copies of the inventory and the letters, and I need to know if any filings have been made in the last 30 days that involve a trust or a deed. Her fingers paused over the keyboard. She looked at me again, then back at the screen. There was a filing last week, she said, a petition for substituted executor. I kept my face still. By whom? Diane Hale, she said, and Eric Hale as interested party. And the court granted it, I asked. No, she said. Hearing set for next month. Then I'm still executor, I said. Yes, she said. Was there a deed filed? I asked. She clicked through screens. Not here, she said, but there was a notice of trust administration submitted as an attachment. Can I see it? I asked. She hesitated. You can request copies. There's a fee. I'll pay it, I said. She printed the pages and stamped them. When she slid them under the glass, I read them standing there. Notice of Trust Administration, Meridian Harbor Trust. Trustee, Diane Hale. Successor Trustee Eric Hale. Assets listed, real property located at, and then my building's address. Attached was a certification of trust with a signature at the bottom, Diane's signature, notarized in the copy I held. No witness line. Just her name in cursive and a date. The certification claimed the trust existed prior to my father's death and that the real property had been transferred into it. I looked up at the clerk. Do you have the actual trust document on file? No, she said. Just what they attached. Is there a recorded deed showing the transfer? I asked. That would be at the recorder, she said. Down the hall, different office. I took the copies and moved fast. At 9:18 a.m., I was at the county recorder's counter. I asked for the grant-to-grantee index for my father's name and the building's address. The recorder clerk pulled it up and printed a summary. There had been a deed recorded 6 weeks after my father died. Grantor, Thomas Hale, deceased, by Diane Hale as trustee of Meridian Harbor Trust. Grantee, Meridian Harbor Trust. I read it twice. A dead man's property transferred by someone who was not the executor, not the personal representative, and not authorized by any court order. And she had labeled herself trustee of a trust I had never seen, claiming it existed already. The clerk didn't care about the story. He cared about the record. Can I see the deed image? I asked. He printed it. The signature line was my father's name, signed in ink that was trying to imitate his hand. Under it, a notary stamp. I knew my father's signature. He signed slowly, heavy, with a slight tremor in the last year. This signature was too clean. It was a younger man's confidence disguised as an older man's hand. Below the notary stamp was a notary name and commission number. Can I get the notary's journal entry? I asked. The clerk raised an eyebrow. That's not here. That's the notary. Can you confirm if the notary stamp is registered? I asked. He checked. Commission is active, he said. Name matches. Active. Not proof. Just another barrier. At 9:33 a.m., my phone buzzed. A text from an unknown number. This is Cal Mercer. Trustee agent. You need to be out by noon. Don't complicate it. I looked at the number, then at my call log showing my earlier voicemail. I replied once. I'm at the courthouse. The service address is wrong. The trust deed appears fraudulent. If you proceed with removal after notice, you and your principal will be included in my filings. He didn't respond. I had 2 hours and 27 minutes. I returned to civil, not to argue with the clerk who smirked, but to find someone with the ability to make her accept paper. Civil had a self-help center for limited matters. It was not designed for this, but it had something valuable. Staff who spoke to the public without glass between them. A woman behind a small desk asked me what I needed. I need to file an ex parte application to stay a right of possession set for noon, I said. I'm not named in the case because they sued occupants. But I'm the person being removed, and I have documents showing the plaintiff's underlying claim is based on a forged deed. She didn't react to the word forged. People in courthouses hear accusations all day. She reacted to the word noon. Do you have the writ? She asked. I handed her the packet and the recorder's printouts. She scanned quickly, then looked at the service declaration. That address number, she said. It's not yours? No, I said. Off by 1. She pulled out a blank form. You can't get into the case easily if you're not named, she said. But you may be able to file a third-party claim of right to possession. That's a statutory procedure. I nodded. I didn't care what it was called as long as it moved. How fast? I asked. She glanced at the clock on the wall. If you can get it filed and get an ex parte in request, sometimes a judge will look at it same day. But you need to show immediate harm and procedural defects. I can show both, I said. She handed me instructions and forms. I stepped to a table and started writing, not with flourish, but with precision. I listed my name, my address, and my interest, executor of the estate that owned the property, occupant with right to possession pending probate and administration. I attached the letters testamentary. I attached the will provision showing the building devised to me subject to life estate in 1 unit. I attached the recorder printout showing the deed recorded after death. I attached the deed image with the questionable signature. Then I wrote a declaration. I didn't write that Diane betrayed me. I wrote that Diane filed a trust notice without the trust instrument and recorded a deed purporting transfer of estate property without authority. I didn't write that Eric was opportunistic. I wrote that Eric was listed as successor trustee and that the plaintiff trust appeared recently in probate attachments. I wrote about service posted in mail to the wrong street number, resulting in default. And I wrote about time. Deputy served writ at 7:18 a.m., enforcement at noon. At 10:11 a.m., I walked back to the same civil clerk window. The same clerk was there. She looked at me and the papers in my hand, and her mouth made the same small movement as before. I told you, she said, you're not listed. I'm filing a third-party claim of right to possession and an ex parte request for stay, I said. Statutory procedure. I'm not asking to be counsel of record. I'm asking to submit a claim. She looked irritated now, not amused. Do you have the fee? I have a fee waiver application if needed, I said, and I did. Filled out but not yet signed. I could pay the fee, but I'd learned that fee waiver applications force a file to exist even if someone wants to turn you away. Paper has weight in systems, not feelings. She took the packet reluctantly and began flipping. This is a lot, she said. It has to be, I replied. She typed and clicked. No, she said. This doesn't go with this case. You need to file it in the eviction case and you're not listed. I kept my voice calm. The claim of right to possession is filed in response to a writ. It relates to this address and this case number. I'm not asking your permission to exist. I'm asking you to accept a filing. Her eyes narrowed slightly, like I'd stepped over an invisible line. She leaned back and glanced toward a door behind her, a door I hadn't noticed before. The door to someone who didn't stand behind glass. She stood up, took my packet, and disappeared through the door. I waited. The line behind me grew. People shifted. A man muttered something about always the same. At 10:24 a.m. she came back. Her smirk was gone. She slid my packet back through the slot but kept 1 page in her hand. The supervisor says you can file, she said, voice clipped, but it's not guaranteed a judge will see it before noon. And if you file a false declaration, that's perjury. I understand, I said. She stamped the first page. The stamp was the first moment that morning that felt like movement. She gave me a hearing request form and said, take this upstairs to Department 12. Ex parte calendar ends at 11. I looked at the stamp time. 10:25 a.m. I had 35 minutes to get in front of someone who could sign something. I moved quickly up the stairs to Department 12. Outside the courtroom, a small crowd stood with folders and envelopes. Some were attorneys, some weren't. The bailiff stood at the door with a list. I need to submit an ex parte request for a stay, I said. He looked at the papers and then at the clock. Calendar's almost done, he said. It's a writ set for noon, I said. I filed at 10:25. He looked at my stamp. His expression changed slightly, not compassion, but respect for timing. Put your papers there, he said, pointing to a table. And wait. I placed the packet on the table with the others. I sat on the bench and watched the courtroom door open and close as names were called. I didn't listen to other people's crises. I watched the bailiff's pen move across his list. Each pen stroke meant a person had been processed. At 10:52 a.m. my phone buzzed again. A text, this time from Diane. You're making this ugly. Your father wanted me taken care of. Leave quietly. Eric is handling it. I didn't respond. A text is not a hearing. It was also evidence of notice and motive if I needed it later. I took a screenshot and saved it to the estate email account. At 10:57 a.m., the bailiff called my name. Inside, the courtroom air was cooler than the hallway. A judge sat above, paperwork stacked. 2 attorneys stood at counsel table for another matter. The judge finished speaking to them and they stepped aside. The clerk announced my case number and said, ex parte application for stay of writ, claim of right to possession. The judge looked at my packet, then at me. You're self-represented? She asked. Yes, I said. Are you the defendant in the unlawful detainer? She asked. No, I said. The defendant is listed as occupants. I'm the person being removed. I have letters testamentary showing I'm executor for the estate that owns the property, and the plaintiff's claim appears to be based on a deed recorded after death without authority. She didn't respond immediately. She read. Judges don't show emotion, they show time. When a judge spends time reading, it means something on the page has triggered caution. Where is plaintiff's counsel? She asked. I called the number listed, I said. He refused to stipulate to a stay. Did you provide notice of this ex parte? He asked. I left voicemail at 7:41 a.m. and called counsel at 8:47 a.m. and called counsel at 8:47 a.m. I also received a text from the trustee agent at 9:33 a.m. confirming they intend to enforce at noon. I handed up a printout of my call log and the screenshots. The bailiff took them and passed them to the clerk, who passed them to the judge. The judge looked at the service declaration. This says substitute service by posting and mailing, she said. Address number is different from the property address on the writ. Yes, I said. Off by 1. The result was I never saw the complaint, never appeared, and a default judgment issued against occupants. She looked at the deed copy I'd attached. You're asserting the signature is forged. I'm asserting it does not match my father's known signature, and it is dated after his death, I said. I'm also asserting that even if there is a trust claim, the transfer of estate property requires authority. There's no court order appointing Diane as personal representative. She filed a petition to remove me, but it hasn't been granted. The judge turned a page. Her eyes paused on the probate documents. She asked one more question, and it was the first time her voice carried an edge. Is there an active probate case in this courthouse? Yes, I said, and gave the case number. The judge nodded to the clerk. Pull up the probate docket. The clerk typed. The judge waited, hands still. The judge looked at the screen, then back at me. You are listed as executor, she said. Yes, I replied. She looked down again. And the petition to substitute executor is pending, she said, reading from the screen. Yes, I said. No order has been entered removing me. She sat back slightly. Then she looked toward the courtroom clerk. Call plaintiff's counsel, she said. Now. The clerk dialed. The courtroom was quiet except for the faint sound of ringing through the speaker. No answer. She tried again. This time a receptionist answered, then transferred. A man's voice came on the speaker. It sounded like Mr. Landry from earlier, but now it was framed by the courtroom, which changes how confident people are. This is Landry, he said. The judge spoke without introduction beyond what mattered. This is Judge Kwan in Department 12, she said. I have an ex parte application in your unlawful detainer matter. The person here is asserting improper service, a pending probate case and a deed recorded after death. Why is the defendant listed as occupants rather than a name? There was a pause, longer than the ones on the phone earlier. Your Honor, Landry said carefully, our client acquired title and proceeded under the unlawful detainer statutes. Occupants are commonly listed when identities are unknown. Identities unknown, the judge repeated, and I could hear how she handled the phrase like a tool she was examining for flaws. Yet your service declaration lists a specific apartment letter and a wrong street number. How did you select that address? Your Honor, we served at the address provided by our client, he said. So you didn't verify it, she said. We rely on our process server, he said. The judge's tone remained controlled, but her questions tightened. This person is in my courtroom with letters testamentary. Probate docket confirms executor status. Your writ is set for noon. You are telling me you're going to remove an executor from an estate asset based on a default judgment where service appears defective and the underlying title may be contested. Your Honor, Landry said, and his voice had shifted to defensive formality. Unlawful detainer is summary. Title issues are not litigated in this forum. I understand the scope, she said. But due process is not optional because you prefer speed. Silence on the line. She continued, do you have evidence that this individual was served at the correct address? Landry didn't answer directly. Service was completed as reflected in the proof. The proof shows the wrong number, she said. He said, it may be a clerical error. It may be, she agreed. And clerical errors get people removed from their homes when the court doesn't act carefully. She looked down at my packet again and then back at Landry on the speaker. I'm issuing a temporary stay of execution of the writ, she said. Effective immediately. I'm setting an order to show cause hearing on the validity of service and whether the writ should be quashed. Your client and the trustee agent will appear. If they proceed with removal after this order, they will face sanctions. Landry's voice tightened. Your Honor, we object. You can object in writing, she said. You can file opposition. You can also explain why your client recorded a deed after the grantor's death, signed as if by the grantor. That document is in my packet. Landry said, we have no knowledge of. You represent the party asserting rights under it, she said. Knowledge can be acquired. The court expects you to acquire it. Then she turned her attention to me. Mr. Hale, she said, your claim raises serious issues. I'm not making findings on fraud today. I am making a finding that enforcement at noon risks irreparable harm given the defects apparent on the face of the service proof and the active probate status. Yes, I said. She picked up her pen. Clerk, she said, prepare the stay order and order to show cause. Include notice to the sheriff's civil unit immediately. The clerk began typing fast. I watched the judge's pen move once, then stop. She signed when the paper was placed in front of her. One signature, clean, deliberate. It wasn't dramatic, it wasn't loud, but it changed what the deputy would be allowed to do at noon. The judge looked at Landry on the speaker again. Counsel, you will ensure your client and agent are notified, she said. Landry said, yes, Your Honor. The judge ended the call without further conversation, then she looked at me. Take this signed order downstairs to the sheriff's civil unit window, she said. Do not assume transmission is instant. Hand it to them. Yes, I said. I took the signed order as soon as the clerk handed it to me. The paper was warm from the printer. I moved quickly through the hallway downstairs across the lobby and to the sheriff's civil unit office, which was a smaller counter near an administrative hall. A deputy behind the window looked up. I have an emergency stay order signed by Judge Kwan in Department 12, I said. Right of possession scheduled for noon at my address. He took the order, read the first lines, and his posture changed. Deputies don't interpret law. They interpret valid signatures. He picked up a phone, dialed, and spoke in short phrases. Stay order received. Yes. Signed. Yes. Immediate. Will note file. He hung up and looked at me. Will stand down, he said. They can't execute with a stay in place. I nodded. Thank you. At 11:24 a.m., I walked back to my car. My hands were steady, but my mind was already on the next pressure point. A stay buys time. It doesn't end the case. I drove back to the building. The streets were normal. People went to work. School buses stopped and opened. Life continued as if a writ of possession wasn't an instrument that could erase someone's morning. At 11:48 a.m., I pulled into the driveway. The trusty agent's car was parked near the curb. Cal Mercer stood on the sidewalk with a clipboard, two movers behind him leaning against a truck. The deputy's cruiser wasn't there yet, but it would have been soon. Carl saw me and started walking toward the steps. "You need to be out," he said. "We're on schedule." I didn't argue. I handed him a copy of the stay order. He looked at it, then at me, then back at the signature line. His jaw tightened slightly. "This doesn't stop," he began. "It stops noon," I said. "It stops removal. It orders you to appear at an order to show cause hearing. Proceeding after notice exposes you personally." He looked at the date and time on the order. "Where'd you get this?" he asked. "In court," I said. "Where it's come from." He stepped back and pulled his phone out, dialing someone. He spoke quietly, turned away slightly. The movers watched him, waiting for instruction. They didn't care about the law. They cared about whether they would get paid today. At 11:57 a.m., the deputy arrived. He stepped out, looked at Cal, then looked at me. Cal walked toward him with the stay order in his hand, holding it out like he was offering a reason to delay, rather than an order that removed his authority. The deputy read it. He nodded once, then looked at Cal. "We're not doing it," he said. Cal's voice went tight. "This is a delay tactic." The deputy didn't respond to that. He responded to the paper. "Talk to your lawyer," the deputy said. "Not me." He walked back to his cruiser. At 12:03 p.m., the moment passed without enforcement. Not because anyone felt mercy, because the signature had been placed on an order and delivered to the right hands. Cal looked at me one more time. "This isn't over," he said. "No," I said. "Now it's finally started in the right room." He gestured to the movers, and they began climbing into the truck. They weren't angry. They were relieved. Work cancelled is still work avoided. Cal drove away. I went inside and sat at my kitchen table again, the same spot where the writ packet had been opened. I set the stay order on top of it, the new paper covering the old. Then I began preparing for the hearing because the court had demanded more than urgency. It had demanded evidence. Over the next week, I did what systems respond to. I built a file. I requested my father's signature samples from bank records where his signature had been captured on account forms. I didn't ask the bank for opinions. I asked for copies. Opinions are easy to dispute. Copies are harder. I obtained the hospital records showing he was hospitalized on the date the deed claimed he signed at a notary's office across town. The hospital chart included nursing notes with timestamps and an entry stating he was not ambulatory that day. I found the notary's business address and sent a formal written request with a journal entry associated with the deed, citing the statute requiring a notary to maintain records. I sent it certified mail. I kept a receipt. Certified mail is a quiet kind of pressure. I also filed a petition in probate to invalidate the purported transfer and to compel Diane to produce the trust instrument. If the trust existed, it would have a creation date, settlor signature, and terms. If it did not, the absence would become its own evidence. Eric didn't call me. He didn't text. He did something else. He tried to move the fight back into the shadows where he was comfortable. 2 days after the stay, I received a notice that Diane had filed a new motion in probate seeking emergency suspension of my executor powers. The motion claimed I was harassing her and interfering with her rightful property. It attached a declaration from Eric stating I had threatened the trustee agent. The declaration was vague, no dates, no quotes, no records, just narrative. Narrative doesn't hold well under oath when the other side brings receipts. The order to show cause hearing in civil was scheduled for 9 a.m. on a Thursday. The probate emergency suspension motion was set for 1:30 p.m. the same day. 2 courts, 2 timelines, same building, different rules. It felt designed to exhaust me and let something slip. I treated it like logistics, not emotion. The night before, I organized my exhibits in 2 sets: civil, service defect; stay, writs, deed, hospital record; probate docket, letters testamentary, probate, will, estate inventory, trust notice, deed recording history, and my request for trust production. I printed everything in triplicate, one for me, one for court, one for opposing counsel. I labeled each exhibit with a simple letter, no commentary, just identification. At 8:35 a.m. the next morning I arrived at Department 12 again. This time plaintiff's counsel was present. Landry stood at counsel table with a binder and a controlled expression. Diane and Eric sat behind him, close enough to be seen but far enough to pretend they weren't directing it. Diane wore black like she was attending a formal event. Eric wore a light blue shirt, sleeves buttoned, no tie. He looked like someone who'd practiced looking reasonable. When the judge entered, everyone stood. When she sat, everyone sat. The room was quiet except for papers moving. The case was called. Judge Kwan looked at Landry. "Counsel," she said, "I issued a temporary stay based on apparent defects. You filed opposition." "Yes, Your Honor," Landry said. He argued that the unlawful detainer was proper, that occupants was common, that service had been substantially compliant, and that title disputes belonged elsewhere. He used the right words. He avoided the wrong ones. Then the judge asked about the address. "You filed a proof of service at the wrong street number," she said. Landry said, "Your Honor, it appears to be a typographical mistake. The process server served the correct premises." "Do you have a declaration from the process server stating he served the correct premises?" she asked. Landry paused. "Not at this time." She looked down at my exhibits. "Mr. Hale," she said, "present your evidence on service." I stood. I didn't look at Diane. I didn't look at Eric. I looked at the judge and the clerk. "The proof of service lists 44187, I said. "The property is 41898. The posted notice would have been on someone else's door. The mailing would have gone to the wrong address. I have a letter from the tenant at 41887 stating they received a posting and a mail piece addressed to occupants and returned it. This is their declaration with copy of the envelope." I handed it up. The judge read it, then looked at Landry. "That is not substantial compliance," she said. "That is no compliance." Landry tried to pivot. "Your Honor, even if service was defective, the court can set aside." "Yes," she said, cutting him off calmly. "And I will, because due process is the foundation of your summary procedure. Without it, it's just speed." She then turned to the deed issue. "I am not deciding title in unlawful detainer," she said, "but when a plaintiff's claimed right to possession depends on a deed that appears recorded after death, signed in the decedent's name, and when the alleged executor is here with letters testamentary, the court will not be used as a tool to facilitate potential fraud." Diane's posture stiffened. It was subtle, but it was the first time I saw her body respond to something she couldn't talk her way around. Eric leaned toward Landry and whispered something. Landry nodded once, then stood again. "Your Honor," Landry said, "my client will voluntarily dismiss this action without prejudice." The judge looked at him. "Without prejudice," she repeated. "Yes," he said. She looked at me. "Mr. Brader." "Hale, do you object to dismissal?" I understood what he was trying to do. Dismissal without prejudice would let them file again, perhaps with corrected service, perhaps with a new strategy. It would let them retreat without consequences. "I object," I said. "I request dismissal with prejudice, sanctions for improper service, and referral for investigation regarding the deed." The courtroom stayed quiet. My words weren't loud, but they landed because they asked the court to acknowledge the larger pattern. The judge nodded slowly, reading the room, reading the documents, reading the behavior. "Counsel," she said to Landry, "I'm not inclined to allow a voluntary dismissal without addressing what occurred. This court's process was used to obtain a writ based on defective service to remove someone who appears on record to be the executor of the estate owning the property. That is not a harmless mistake." Landry's face tightened. The judge continued. "Here is what I will do. I will set aside the default judgment. I will quash the writ. I will order plaintiff to pay Mr. Pay. Hale's costs associated with the ex parte and hearing, including filing fees. I will also issue an order to show cause re-sanctions against counsel and plaintiff for the defective proof of service. Landry started to speak, but the judge raised a hand slightly, not a dramatic gesture. A procedural one. Further, she said, I am forwarding the deed and related records to the district attorney's office for review. I am not making a criminal finding. I am noting an issue that warrants review. Counsel, you may advise your client accordingly. Diane turned her head slightly toward Eric. Eric's mouth moved once, tight, then still. The judge looked at me. Mr. Hale, she said, this does not resolve your probate matter. You will address title and executor authority there, but this court will not remove you today, or at any time, without proper service and due process. Yes, I said. The judge signed the order on the bench. Another signature, another timestamp, another record. The hearing ended. People stood. The judge left. The courtroom emptied in controlled steps. In the hallway, Landry walked past me without speaking. Diane stopped a few feet away. She didn't approach. She didn't need to. Her voice carried in the hallway even when quiet. You think you've won something, she said. I looked at her and answered with facts, because facts were the only safe language with someone who used family as leverage. The writ is quashed, I said. The default is set aside. There's an order for costs, and the deed is being reviewed. Eric stepped closer, still careful, still trying to look like a person who wasn't implicated by his proximity to her. You're making a mess, he said. It was already a mess, I said. I'm documenting it. He looked at me as if he wanted an emotional reaction he could use later. I didn't give him one. Probate is at 1:30, I said. If you have evidence, bring it. I walked away. At 1:30 p.m., in probate, Diane's motion to suspend me felt smaller in the light of the civil ruling, not because the probate judge cared about my stress, but because another court had just acknowledged on record that I was likely targeted through defective process. The probate judge reviewed the filings and asked Diane's attorney one simple question. Do you have the original trust instrument? The judge asked. Diane's attorney hesitated, then said, Not at this time, Your Honor. Do you have evidence the decedent executed a deed transferring the property into the trust prior to death? The judge asked. The attorney said, We have a recorded deed. The judge looked at the date. Recorded after death, he said. Diane's attorney tried to argue. The judge stopped him with a procedural firmness. I am not suspending an executor based on accusations without documentation, the judge said. If you want to challenge executor authority, you follow the timeline and produce evidence. Motion denied without prejudice, and I am ordering production of the trust instrument within 14 days. Diane's face tightened. Eric's eyes stayed on the table. The judge then looked directly at me. Mr. Hale, he said, as executor, you are reminded your duty is to the estate. Document everything. Maintain the property. Do not take self-help measures outside the court. I understand, I said. That was the end of it in that room. No speeches, no reconciliation, just orders. The next 2 months were slower, but the pressure didn't disappear. It changed form. The notary responded to my certified letter with a short refusal, stating her journal was private. I filed a petition to compel production under the statute. The court granted it. When the journal entry arrived, it listed the signer as Thomas Hale, but the identification used was a driver's license number that had expired 3 years earlier. The thumbprint box was blank. The notary's handwriting in the journal was inconsistent with her other entries, as if someone else had filled it out quickly. Those weren't dramatic discoveries. They were small fractures that, once recorded, forced the structure to weaken. The district attorney's office sent a letter acknowledging receipt of the referral and stating they were reviewing. It didn't promise anything. It didn't have to. The existence of the letter mattered. It meant someone else was now watching the record. In probate, Diane eventually produced a trust document. It was 4 pages long. Generic language, no schedule of assets attached, no signature from my father that matched his bank forms, and the creation date typed in a font inconsistent with the rest. Her attorney tried to argue that it was valid anyway. The probate judge didn't raise his voice. He simply compared the signatures and asked for the original. They couldn't produce it. The judge ordered a handwriting expert evaluation if they intended to rely on it. He also ordered Diane to account for any estate property she had controlled and prohibited her from further recording instruments against estate assets without court permission. Eric stopped attending hearings after that. He began sending his attorney alone. The building stayed in my control. Tenants stayed in place. Rent checks continued. Repairs continued. Taxes were paid. The system didn't reward me. It simply stopped allowing them to use shortcuts. One morning, 3 months after the writ, I received a new envelope in the mail from the recorder's office. Inside was a recorded document, a notice of rescission regarding the deed Diane had recorded. It wasn't signed by Diane. It was signed by her attorney on behalf of the trust, likely after realizing that keeping the deed active was now a risk. The rescission didn't absolve anything. It was a tactical retreat, but it mattered because it changed the public record back toward reality. I placed the rescission in my father's folder. I added a note with the date, the instrument number, and the chain of events that led to it. I didn't write about Diane's face or Eric's silence. I wrote about the filings, the orders, the timestamps. Later that same week, Cal Mercer sent one final text. "We're closing this file." I didn't respond. Closure texts are for people who want the last word. The record already had it. On a quiet afternoon, when the building's hallway was empty and the only sound was the older tenant downstairs watching television at low volume, I went into the basement storage and found my father's old metal lockbox. Inside were things he didn't keep for sentiment: the original deed, tax receipts from decades back, a small notebook where he tracked payments in neat columns. He had always trusted paper more than promises. I understood why now. The first morning, when the deputy handed me a writ and told me I had until noon, it would have been easy to focus on the insult of it, the humiliation of being treated as a category. But what actually moved the outcome was not the feeling of being wronged. It was the ability to show, line by line, where the procedure broke and who benefited from the break. A clerk smirked and said I wasn't listed. That was true in the narrowest sense. The system didn't know my name because someone had designed it that way. But systems can be taught. They learn through filings, through stamps, through signatures, through orders carried by hand to the right window before a deadline hits. One signature changed everything because it was backed by the right documents at the right time, not because anyone cared about fairness as an idea, but because fairness is built into procedure when the procedure is forced to acknowledge the facts. If you've seen something like this happen, where a person tries to use institutions like tools, tell me what part of the process you think matters most. I read the comments. And if you want more stories built around records, reversals, and the quiet moment when a system finally has to correct itself, you can subscribe.